All right, let's get real for a second. Have you ever walked into a government building, followed all the rules, filled out every form perfectly, only to be told no just because some bureaucrat didn't like your reason? Imagine that, but for your fundamental right to self-defense. For decades, honest folks in states like California and New York have been told exactly that when applying for a concealed carry permit. Sorry, your desire to not get mugged isn't a good enough reason. Well, the Supreme Court finally looked at that system and dropped a 6-3 legal bombshell that sent a shockwave through the entire country. This isn't just some dusty court case. This is the biggest shift in Second Amendment law in our lifetime, and it directly impacts how you, me, and everyone we know can protect themselves. Here at Weapons Survival Gear, we're cutting through the legal jargon and the media spin to give you the straight scoop. No fluff. We're talking about what this really means for you. Whether you're carrying a full-size Glock 19 or a Ruger LCP in your pocket, this is need-to-know stuff. The Bruen ruling on jamming the system. The case is New York State Rifle and Pistol Association v. Bruen. In June of 2022, the Supreme Court absolutely dismantled New York's century-old carry law. For years, New York had this thing called a proper cause requirement. You had to prove to a government official that you faced some unique, special danger to get a permit. I want to protect my family didn't count. You basically needed a restraining order against a specific person or a job hauling diamonds. It was a system that guaranteed criminals could carry whatever they wanted, while law-abiding citizens were left defenseless. Justice Clarence Thomas, writing for the majority, basically said, enough. He laid down the law, stating that the Second Amendment isn't a second-class right you have to beg for. Any gun law has to align with the text, history, and tradition of the Second Amendment. What does that mean? In simple terms, if the government couldn't restrict it back when the ink was still drying on the Constitution, they probably can't restrict it today. Forcing you to justify your right to carry? The court said that's a hard no. For anyone who's ever felt their rights were stuck, this ruling was like clearing a nasty stovepipe jam. All of a sudden, things started moving again. The ripple effect. A national fight. Now, this decision didn't just hit New York. It sent tremors out to every other state with these subjective may-issue laws. California, New Jersey, Maryland, Hawaii, they all operated like private clubs where the government got to be the bouncer, picking and choosing who could carry. Bruen effectively forced these states toward a shall-issue system. If you're a law-abiding citizen who passes the background check and completes the required training, they have to give you a permit. End of story. But don't pop the champagne just yet. Some of these states are digging in their heels, playing games. New York, for instance, immediately passed a new law that turned huge areas into so-called sensitive places, where carry is still banned. We're talking parks, subways, Times Square, basically everywhere. It's like they're saying, sure, you have the right to carry, just not anywhere useful. I have a buddy who owns a small business in Maryland. Pre-Bruen, he was denied a permit even though he carried cash deposits late at night. The state said his general fear wasn't good enough. After the ruling, he reapplied and got his permit. He now carries a Springfield XDS and sleeps a whole lot better at night. But his friends over in New Jersey are facing a new nightmare. Mandatory training that costs a fortune and character references that feel more invasive than a top-secret security clearance. This fight is far from over. The new standard: text, history, and tradition. Here's the part that gets a little nerdy, but it's also the most powerful part of the Bruen ruling. The court created a brand new test for all gun laws. Forget what politicians feel is, quote, reasonable. The only question that matters now is this: does the law have a twin from the 1700s or 1800s? Think about it. When a state tries to ban your standard 15-round magazines, the court now has to ask, was there a law in 1791 that limited how many musket balls a guy could carry in his pouch? The answer is no, of course not. This test is a legal bazooka, and we're already seeing it work. In a case called Duncan v. Bonta, this test was used to strike down California's 10-round magazine limit. Other laws, like those that force you to transport your handgun locked up and separate from your ammo, are also getting shredded because they have no historical roots. The Supreme Court basically gave lower court judges a time machine and said, go back and check the original rulebook. If it's not in there, it's unconstitutional. For us, that means decades of restrictive, pointless gun laws are finally on the chopping block. What's next on the battlefield? So-called assault weapon bans? The question is now whether the Founding Fathers banned any class of common, effective firearms. The answer is no. Magazine capacity limits? We just talked about that. Even things like Maryland's handgun roster, which limits the models you can buy based on arbitrary features, are now being challenged. Did the founders care about loaded chamber indicators or magazine disconnect safeties? Not a chance. Even federal rules are being hit. The ATF's recent shenanigans with pistol braces are being fought in court using this exact historical standard. It's a chain reaction. Every unconstitutional law that falls makes it easier for the next one to get knocked down, but the opposition is playing dirty. Some judges are ignoring the ruling, and states are passing those tricky new laws we talked about. They're trying to drown us in a sea of paperwork and gun-free zones. This is going to be a long, drawn-out battle, and some of these new cases will almost certainly end up back at the Supreme Court. Your post-Bruen playbook. Staying sharp and ready. Okay, so that's the legal landscape. Now let's talk about what this means for you, the everyday carrier. What's your playbook? First, if you're in a formally restrictive state, this is your moment. Thousands of people who were denied permits for no good reason can now get them. This is a massive power-up for your personal safety, but with that right comes huge responsibility. This is where you need to get serious. Know your laws. Cold. They are changing constantly. Bookmark sites like handgunlaw.us or the USCCA's legal resources page. Check them monthly. Ignorance is not an excuse. Invest in quality gear and training. A right you can't exercise safely and effectively is useless. If you're carrying a compact like a SIG P365 or a Springfield Hellcat with an optic, get a quality holster that's actually designed for it. I've been running a Tier 1 Concealed Axis Elite for my appendix rig, and the retention and concealment are top-notch. More importantly, practice your draw. Don't just go to the range and punch paper. Practice drawing from concealment under a timer. Legal carry is not the same as easy carry. Document everything. In this climate, a simple dash cam in your car can be the best legal defense money can buy. It provides an unbiased witness if you're ever in a questionable stop or a self-defense situation. Support the heavy hitters. We're not in this fight alone. Groups like the Second Amendment Foundation and Gun Owners of America are the legal commandos on the front lines. They're the ones suing California over the roster and New Jersey over mag bans. They run on our support. Become a member, share their updates, keep the community informed and tight. Being a responsible gun owner is about more than just hitting your target. It's about being a student of the law and a defender of our rights. So that's the breakdown of the Bruen decision. It's a landmark win, but it's also the start of a whole new chapter in the fight for our rights. Now I want to hear from you. What's the craziest anti-carry rule or requirement you've seen pop up in your state since this ruling? Drop it in the comments below. I read every single one. If this video helped you understand what's going on, do me a favor and hit that like button and share this with your buddies from the range. And make sure you're subscribed to Weapon Survival Gear for more deep dives on the gear, the laws, and the mindset you need to stay ready. Stay safe, stay informed, and I'll catch you in the next one.